On 7th February 2025, the NRM Parliamentary Caucus, chaired by President Yoweri Kaguta Museveni, resolved to withdraw the UPDF Amendment Bill 2024 to incorporate new proposals in light of a landmark ruling passed by the Supreme Court on 31st January 2025 that deemed the trying of civilians before the General Court-Martial unlawful. This followed the bill's swift withdrawal in a motion moved by Government Chief Whip Denis Hamson Obua on Thursday 20th February 2025 in Parliament.
The withdrawal of the bill is primarily to enrich the bill and to ensure that we comply with the ruling of the Supreme Court of the Republic of Uganda.
Honourable members, having listened to the minister's justification for withdrawal of the bill, I now put a question that Uganda People's Defence Amendment Bill 2024 be withdrawn as proposed. Those in favor say and the contrary nay. The ayes have it. Honourable members, the UPDF Amendment Bill 2024 stands withdrawn.
After the recent NRM Caucus meeting that took place at State House Entebbe, in light of discussing, among other things, the comprehensive proposals in the withdrawn UPDF Amendment Bill, the Government Chief Whip made revelations to the media on what transpired. He stated the NRM MP's decision to support the trying of armed civilians before the military court with respect to the right to appeal through civil courts.
Civilians who acquire specified firearms illegally be tried by the military court-martial in the first instance with the right of appeal through the civilian courts.
The new proposal also re-emphasizes that court-martial will be subordinate to civil court.
That provision be made to provide for right of appeal from decisions of court-martial to civilian courts, implying the court-martials will be subordinate to the civilian court.
With the recent debates that rose especially among opposition MPs on the government's attempt to dismantle the ruling of the Supreme Court, the Minister of Defence and Veteran Affairs, Jacob Oboth, dismissed the claims, stressing that their intention is to rather have the bill abide with the ruling.
Nobody is trying to defeat the decision of Supreme Court. What the Parliamentary Caucus and the government is doing is to conform. Judges make laws, and when they make laws through advisory or whatever means, we have to make laws that conform to what judges are saying, and that's what the caucus has labored into. So there's no contradiction. So all will be well. They have adopted the general principles, wait for the bill when it will come.
He also explained that the amendments in the bill completely complied with the Supreme Court's concern on the tenure and appointment of General Court-Martial leadership to be comprised of legal professionals.
This amendment complies and adopted the proposals by Supreme Court that all the leaders, the chairpersons of those courts-martial, will be people qualified to be advocates. And from the advocates, there will be lawyers up to the top. The first one is a unit, courts-martial, will be presided over by a lawyer, but with others who will act as assessors. This is popular participation at that court level, and even at the division level, advocate and equivalent of who can be appointed the High Court judge, and the General Court-Martial will be headed by a lawyer also can be appointed, who qualifies to be a judge of High Court, with the two other advocates in that who are military officers.
With these proposals gaining adhesion, all eyes will be on Parliament as legislators will debate the amendments of the bill once it is retabled in Parliament.